You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant. Both sides ready to proceed. It's been brought to my attention that the jury has reached the verdict. State?
The state's ready to proceed, Your Honor.
Defense?
Defense is ready.
To those in the gallery, please do not express any signs of approval or disapproval upon the reading of the verdict. Let's return to jury. State recognizes the presence of the jury.
We do, Your Honor.
And does the defense.
Yes, sir, we do.
Good afternoon, ladies and gentlemen of the jury. Have you reached the verdict?
Yes, sir.
Would you hand the verdict form to the court deputy, please? Will the defendant rise along with counsel? Madam Clerk, you may publish the verdicts.
Thank you, Judge. In the Circuit Court for the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus Casey Marie Anthony. As to case number 2008 CF 15606-0. As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, on this 5th day of July, 2011, signed foreperson. As to the charge of aggravated child abuse, verdict as to count 2, we, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of aggravated manslaughter of a child, verdict as to count 3. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 4. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 5. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 6. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer. Verdict is to count 7. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson.
Madam Clerk, you may poll the jury.
Yes. Juror number 1, were these your true and correct verdicts? Pardon? Juror number 1, were these your true and correct verdicts? Not guilty. Were they all your true and correct verdicts?
Yes.
Juror number 2, were these your true and correct verdicts?
Yes.
Juror number 3, were these your true and correct verdicts?
Yes.
Juror number 4, were these your true and correct verdicts?
Yes.
Juror number 5, were these your true and correct verdicts?
Yes.
Juror number 6, were these your true and correct verdicts?
Yes.
Juror number 7, were these your true and correct verdicts?
Yes.
Juror number 8, were these your true and correct verdicts?
Yes.
Juror number 9, were these your true and correct verdicts?
Yes.
Juror number 10, were these your true and correct verdicts?
Yes.
Juror number 11, were these your true and correct verdicts?
Yes.
And juror number 12, were these your true and correct verdicts?
Yes.
Thank you.
Okay. Will counsel and the defendant approach the podium? Not all the counsel, but just Representative Sample. Casey Marie Anthony, a jury of your peers, having found you not guilty as to the charge contained in count 1 of the indictment, murder in the first degree, at this time, I will adjudge you to be not guilty. As to count 2, the crime of aggravated child abuse, a jury of your peers having found you to be not guilty, the court will adjudge you to be not guilty of the crime contained in count 2. As to count 3, aggravated manslaughter of a child, a jury of your peers having you found you not guilty, I will adjudge you to be not guilty of that count. As to counts 4, 5, 6, and 7, providing false information to a law enforcement officer, I will adjudge you to be guilty of those counts in order that you be fingerprinted here in open court at this time. It has to be an open court. Okay, Mr. Baez, Mr. Mason, will you be prepared to go to sentencing Thursday or Friday of this week? Okay, then we'll set sentencing Thursday at 9 a.m. in this courtroom. Okay, are there any other matters that we need to take up at this time?
Nothing from the state, Your Honor.
Ladies and gentlemen of the jury, on behalf of the citizens of the Ninth Judicial Circuit, I would like to express my sincere thanks and appreciation for your service as jurors. You are all residents of Pinellas County, Florida, and we came over there, met with you, questioned you, and took you away from your families for a very extended period of time. And for that, I say thank you. As I told you when I first spoke with you, in talking about jury service that one of the most important obligations of citizenship, in my opinion, was service on a jury. I tell you, it was very important that if we believed in that constitutional provision that provides a right to trial by jury, that it was important for people to serve no matter what that sacrifice would be. As you can tell by some of the questions that some folks answered, a lot of people did not want to serve. You knew it would be a hardship, and you were candid with the attorneys. You answered all their questions, and you served. And for that, we thank you. I would also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and vote shall remain their private affairs as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your jury work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you. From the media, from attorneys, or elsewhere, it will be up to you to decide whether to preserve your privacy as jurors. Again, thank you. You're hereby discharged, and I will see you shortly back in the jury room. Thank you. You may be seated. This court is in recess.